your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
And we found him somewhere, I don't know, sunning himself on some Hawaiian island. Have you run away to Hawaii, have you, David?
I know, didn't need a passport to come to Queensland.
Well, not now. You did for a while there, but now they let you in. Great to have you on board. Did we have any homework from last week, David?
We did. We had Chris from Northwood, and Chris was a lady who had the question was, nobody obeys the please give way to stop signs. And I must say, though, we got the fine wrong. The fine for disobeying a give way to stop sign is now $905.
Ooh.
So, but then again, it's if there's no enforcement officer who sees the offence, nobody's going to do anything. And the issue then moves from that, and I understand Chris's frustration, is what liability does she have as a stock owner in circumstances where there is a collision between an animal and a vehicle? And I would have said that based on some changes based on the way the road rules are written, I'm all in favour of Chris's position, because it's they're committing an offence by not travelling at a speed that enables them to avoid any animal that even approaches them. So even if the animal charges in front of the car, it's going to be the driver's problem rather than the stock owner's problem.
All right.
Yep.
Well, thank you for clarifying. 1300 222 774. David Whiting is here. He's ready, and he's going to take your calls. Linda in New Gisborne, go ahead.
Good morning, David and Virginia. I have a query about who has the rights over a burial plot. I buried my son 2 years ago. Make arrangements for me to be interned with him. I spoke to the cemetery and I was told that the government, and we have done this for previous relatives, I spoke to the cemetery and they said the government doesn't allow you to do that anymore. So I'd like clarification if you can.
Okay, there's a concept called the right of burial. All right, now, and that if you have the right of burial, you're able to determine who goes in the plot.
Okay.
Now, and as a general proposition, so if I take my family, my dad dies first, so my mum owned the right of burial. And when Mum died, there was no difficulty putting her in the same plot because there was no issue as to who owned the right of burial. But a couple of years ago, I had a problem where Mum and Dad were both in the plot, and they had a daughter who was in her 70s or 80s. And when she died, the question was that because no one had ever taken out a grant of probate, there was the right of burial belonged to Dad, who died 60-something years ago. So there is a process by which you can satisfy a cemetery trust that you are the person entitled or most entitled to the right of burial. But it is possible. So I would be going back to the cemetery trust and say, who owns the right of burial for that plot? And it may be that it belongs to a lawyer as the executor or something like that.
Right.
So you can get access to it that way.
Okay, thank you very much. That's very helpful.
I'm glad that's helpful, Linda. Thank you so much. John in Carlton, I think we might stay on a theme here. Good morning. John, hello. Good morning.
Oh, hi. Yeah. My dad passed away without a will, and my mother said she didn't want the inheritance. Is it possible then not to have the inheritance pass through her account or something, or so not following the rule
so
about?
Your dad had no will?
Yeah.
Okay. Well, the process, there's the technical answer and then there's the Centrelink answer. From a technical point of view, if you're using a solicitor or somebody like that to administer the estate who's got a trust account, then it would be possible for all of the estate money to go into that account. and for your mum, presumably on the basis that she's entitled to most or all of what your dad left, to direct that the payment be made to third parties. So it could be to you or to your siblings or to a charity or whatever. She would be entitled to do that. Now, that's from a trust point of view. From a Centrelink point of view, whatever it is that she chooses to give away will probably, by law, would impact her pension. Right? So let's say she's getting $200,000 from your dad or your dad's estate, and she says, no, I want to give it to the kids instead. Centrelink's approach is that she's given away $200,000 of her assets and it will affect her pension. So you need to be very careful about what you do. But it is possible to do it without passing it through your mum's bank account.
Yeah. I'm actually applying the grant of probate myself. So...
Well, if you're the executor appointed by the will, then and you're doing it yourself, what you will need to do is apply for a tax file number for the estate, and when you've got a grant of probate, you apply for the tax file number. You can then open a bank account in the name of the estate, and you can put all of the money in that account. It doesn't need to go into your mum's.
Can I ask, John, why your mother doesn't want to receive her inheritance?
Well, partly, I think my dad told her some years ago, so that's the thing. And also, there's a sentencing issue as well, so, yeah.
Okay.
Yeah.
Well, I hope that's clear for you, John, and that's helpful. Thank you for calling in. Daniel in Footscray. Daniel, what's the help you need today?
Oh, hi, Virginia and David. My question is, if I believe there's a Victorian law that's unconstitutional, would it be possible just through filling out forms to self-represent myself in the High Court and sort of initiate a case and then to present it myself in the High Court? Would that be possible, David?
You're a brave man. It is technically possible to be a litigant. I've actually made an appearance in the High Court, and it was mildly terrifying. We're talking about a couple. Again, if you have an issue about the constitutionality of a Victorian law, that's then that's a matter that you would, in the first instance, run in a Victorian court. And if you were to look at what the laws are in Victoria, the Parliament of Victoria can make any law that it wants that meets the requirements of being for the peace, order and good government of the state of Victoria. If you are having a constitutional question in the High Court, then what you're actually trying to do is interpret the Constitution as it applies to the issue. Is it possible for you to do it yourself? The answer is yes, but as a general, in most matters in the High Court, you require leave. So there would be a preliminary hearing on your application. Could you do it? Yes, you could.
Would you want to do it? Is another question, David, and I'll put that. Would one want to do that all oneself, David?
Well, no. There's the stage you get to two questions. There's the question of money and there's the question of principle. I can understand that people want to bring matters to the attention of the High Court. Over the years, there have been self-represented litigants on things such as state aid to Catholic schools.
Yeah,
is an issue.
Daniel, can I ask you just briefly, what is the matter that you would want to bring to the High Court?
Okay, in the state laws, when it comes to intervention orders, the person who's the respondent or the accused person, isn't allowed to cross-examine the accuser or the person who is the protected person in an intervention order. You know,
that's right.
So, and it hasn't yet been proven, because it's only in the start of the contest whether the person is actually guilty or has done the wrong thing or not. But you're still not allowed to cross-examine.
Have you got an intervention order against you?
Yes, that's right. Yes, okay. And I'm the respondent, and I'm not allowed to. I have to go.
I can tell you that that's a matter that the High Court wouldn't take at first instance. That's a matter that you would normally take on a referral in the Supreme Court. And at that stage, what you're then doing is looking at what are the terms of the legislation under which the allegation against you is made, and then it's a question of whether such a law is for the peace, order and good government. Now, we know that in a large number of sexual crime allegations, there is no right to cross-examine the accuser.
Okay. Yeah, well, exactly. And that's been a established and protected right for pretty obvious reasons.
For a long time.
For a very long time. Okay, well, good luck with that. Let us know how you get on if you decide to proceed to the Supreme Court here in Victoria. Laurie from Burton's Lookout. Good morning, Laurie. Go ahead.
Good morning. You hear me okay?
Yep, go ahead.
I just had a phone call from a friend of mine last night. He's an Indian guy who's only lived here a few years. He's paid a bond for a room in out in the southeastern suburbs, and he's from what I can gather in the phone call, he only saw it last in the dark. He didn't see it in full daylight, and the bond was fairly substantial. He also paid 1 month's rent, and he and the person that they were going to go into the room with, after 2 days after they paid the bond, they decided that this room wasn't suitable. They didn't actually get to move in.
Yep. Do they want the bond back?
No bond, no.
No. I asked, do they want the bond back and they can't get it back? Is that the issue?
Yes. Yeah. And the advance.
Is it a rooming house or is it a private deal? For example, people near universities sometimes will let a room to a student. And there are other people who run rooming houses that have 8, 10, 12 people in them. Which is this?
I am not too sure on that, as I only received a phone call last night.
If it's a rooming house, then you have all of the protection of the Residential Tenancies Act. There are rules in relation to what you might call the normal tenancy and rooming houses and caravan parks offered in that. If it's a private arrangement, then you can still go to VCAT, but it's not a residential tenancy issue, and to a large extent it will depend upon what you've signed.
Okay. I did ask him to email me the details or the paperwork, but at this stage I haven't received it. Okay. This was a phone call at about 10 o'clock last night.
There might be a few more details to get, but they're the basic principles there, David.
Yes, and if it's from a college or a university, they will also have a housing officer, and so if you've got a concern that relates to that, talk to the housing officer, and there might be some pressure that can be put at that end.
Good luck with that. Sina in Thomastown, how can David help?
Oh, hello. Yes. David, our mother passed away in June last year, and she owned an independent living unit in an aged care facility. So it's a separate unit. She owns the title as well. We've sold the property and we were going to settle, but before we can settle, we have to agree to an amount to pay the aged care facility. And there's just some ambiguity about the wording, and I'm just interested to find out what you think this means. It says Mum was in there for 5 years and 4 months, and it says that the number of years is, if there is a part of a year, that shall be counted as a whole year from the date the unit owner executes this deed. So what we're arguing is, we understand about the whole year, that's perfectly fine. The deed was signed on the 16th of September 2016, and we were meant to settle yesterday, the 7th of February 2022. And what we're arguing is, from the date the unit owner executed this deed is the beginning of the year, but the owners are saying, no, 2016, that whole year is considered as 1 year, and then this year, 2022.
Oh, so they want? Do they want
7 years?
No, I'm on your side. I say it's 6 years. I say that's outrageous, but I'm at 6 years on what you told me, because the year starts on the date she signed. From what you've told me.
Thank you. So where do we go? So they're playing hardball, which is fair enough. But I just wanted to find out, where do we go to? How do we make them understand that they're in the wrong?
Have you got somebody acting for you on the sale who provided that opinion, or?
A conveyancer, we do.
No, well, that would be fine. I mean, you might like to pay someone to provide the advice, or you might do. I mean, I'm interested in moving things along, so it's possible for you to settle under protest. So you're simply just saying, in essence, I'm giving you the money, but I'm not agreeing with your position, and I'm going to sue you for the refund.
All right. So we're concerned, obviously, if we pay out the money, we'll never get it back. But we can, what is it, settle under protest?
You settle under protest because it's incredibly likely that the operator of the facility where your mum had the independent living unit will still be around for a long time to come and will have resources from which you can get the money back.
Yep. Okay. So sue for a
look
refund.
very carefully. Look at settling under protest and getting a refund.
Perfect. Thank you so much for your help.
I hope that's helpful. Good on you. Thanks so much, Sina. Kathy in Cheltenham, what's going on? Hi, Kathy.
Hi, thanks for taking my call. I have a question with regards to the new legislation that's come out for landlords with regards to compliance for electricity, gas, and the regular inspections that occur. We have a reasonably new build, so probably about 6 years old, and it was built by a volume builder, and a couple of non-compliance plumbing issues were found. So I followed up with the builder because I thought, well, those issues were current at the time of the build, so they should be the ones to fix it, not us. So I have contacted them. They said, well, we issued compliance certificates at the time, so no, it was compliant. However, these items have not been touched since the build, so obviously it wasn't. So how do you pursue it? Because, basically they're just, ignoring our emails now.
Is it possible that the regulations have changed since you built?
No, I actually did I did a search to find out that it was current at the time of the build, and it was. Those legislation, those requirements were current at the time of the build.
Then if you want to take them out, and how much money are we talking about?
Look, probably not a lot. I haven't really inquired about how much it would cost to repair, but I just thought, well, why should we be out of pocket when they didn't do it properly in the first place?
I agree with you. Then the people you complain to are the people who license the plumbers and gas fitters. So you're talking to the Building Commission about, you found some work that they did. Your other issue, of course, is that if it's 6 years old, your right to sue for breach of contract is probably gone. You might, however, look and see whether it's a matter which would form part of the building warranty, and to some extent that will depend upon how severe the problem is. So if it's a significant issue, it might be part of your builder's warranty. If it's what you might otherwise consider to be a maintenance item, then it's long gone.
Okay. All right. So
just quickly
thank
now,
you very much.
I'll have to go to some other calls, Kathy, but anything else?
No, that's okay. I was just going to say thank you.
Okay, thanks so much. I hope that's helpful. Sue in Tarneit, you've been asked to be the next of kin for someone. What's going on?
Yeah, just from an acquaintance, not someone terribly close. If I would be prepared to be listed as their next of kin, as they're totally annihilated from their family. I'm just wondering what obligations or any legal requirements would be attached to that if I accepted that.
In the event that you remember, them nominating you is not the same as you taking on the role. But in the event that you take on the role, or you're nominated, in the event that you say acknowledge that you're taking on that role, then you'll require. It's really just a question of somebody might ask you for permission for something. So, in the event that they don't have a medical treatment decision maker appointed, you'll get asked. In the event that they die, then somebody might come along to you and say, well, what now happens, because you're the next of kin.
So there are actually no legal requirements?
No, none at all.
Okay. Does that make you comfortable accepting then, Sue?
Possibly, yeah.
All right.
I'd go a bit further. And I would be going back and saying, I need some more information. If you die, who do I ring, right? And the other thing that you might think about is that it's possible for them to complete an advanced care directive, and that will make all the tough decisions that you don't want to be put in a position to make.
It's a smart idea, because then the hospital has all the documentation and they know how to proceed in various events. Yep. Good luck, Sue. It could be a lovely thing to do, but also potentially puts you in a tricky position. It's all we have time for right now. But, David, I'm glad we could get you up on the line. Finally, enjoy your holiday. We'll see you back in Melbourne soon.
Monday. Thank you.
Monday. Oh, yes. All holidays come to an end at some point, even for David Whiting.